Thank the delegation of the United Arab Emirates for its presentation. I invite the next participating delegation, the United States of America, to address the court. I call upon Mr. Richard Vizek to take the floor.
Thank you, Mr. President and members of the court. I am honored to appear before you today on behalf of the United States of America. The court has a serious and difficult task before it. In the time since the General Assembly first requested this advisory opinion, the international community has confronted the horror of the terrorist attacks of October 7, including the taking of hostages who have yet to be released, and the ongoing conflict between Israel and Hamas, which has had severe, widespread, and tragic consequences for Palestinian civilians in Gaza. Violence, including extremist settler violence, also surged in the West Bank. The United States, along with others, is engaging intensively with the Palestinians, with Israel, and with other states in the region and within the United Nations, not only to address the current crisis, but to get beyond where we have been, namely to advance a political settlement that will lead to a durable peace in the region that includes lasting security for Israelis and Palestinians and a path to Palestinian statehood. The Security Council and the General Assembly remain convinced that the Israelis and Palestinians must take the steps necessary to resolve their conflict and create such an enduring peace. These principal organs of the United Nations have laid out and continue to endorse the path to achieve that peace through the principles first articulated in Security Council Resolutions 242 and 338. Those resolutions are the core of the established framework within which the court should address the legal questions before it. This court's advisory opinion will have consequences for the parties to the conflict and for the ongoing efforts of all of those working to achieve a durable peace. It will do so for the Security Council, which bears primary responsibility for maintenance of international peace and security. It will do so for the General Assembly, which requested the court's advice. And it will do so for the other members of the international community. Throughout the tumultuous and often violent history of the Israeli-Palestinian conflict, the United Nations has been consistent in its support for the proposition that a comprehensive, just, and lasting peace requires negotiations between the parties to the conflict. As the court can see in the submissions before it, there is broad international support for achieving a negotiated solution to the conflict that will give rise to a Palestinian state, a solution in which two peoples live side by side with equal measures of freedom, security, opportunity, and dignity, and which results in broader regional integration and stability with respect for the right of all states to live in peace within secure and recognized borders. It is for these reasons that the United States encourages the court to ensure that its opinion preserves and promotes the established framework and the prerogatives of the principal political organs of the United Nations to identify the appropriate measures to address this particular matter of international peace and security. Mr. President, members of the court, it will not be possible in this statement to address every assertion or underlying assumption, including those with which the United States disagrees. Instead, my statement today will proceed in two parts. First, I will discuss the established framework set forth and endorsed by the Security Council and the General Assembly, as well as the widespread recognition that the parties must return to that framework as the pathway to durable peace. I will then address guiding considerations for the important role the court should play in preserving and promoting that framework. Mr. President, members of the court, the first time the General Assembly sought this court's advice in relation to the Israeli-Palestinian conflict, the court recognized that, and I quote, This tragic situation can be brought to an end only through implementation in good faith of all relevant Security Council resolutions. In particular, resolutions 242, adopted in 1967, and 338, adopted in 1973. This statement remains as true today as it was then, as the Security Council, the General Assembly, and the international community have consistently affirmed, and as many of the submissions in these proceedings recognize. As set out in our written submissions, the established framework for achieving a comprehensive and enduring peace is anchored in Security Council resolutions 242 and 338. At their core, these and subsequent resolutions call for the application of two interdependent and inseparable requirements for a just and lasting peace. One is the withdrawal of forces from occupied territory, and the other is peace and security for states in the Middle East through acknowledgement of the sovereignty, territorial integrity, and political independence of every state in the area. In identifying these interdependent requirements, the Security Council decided that the withdrawal of Israeli forces relies on and is bound together with the termination of belligerency, mutual recognition and respect for the right of Israel and every other state in the region to live in peace within secure and recognized boundaries, free from threats or acts of force. This principle is referred to by both the Security Council and the General Assembly as land for peace. In the years since, these interdependent and inseparable requirements have been the organizing principle of historic peace agreements, first between Israel and Egypt, and then between Israel and Jordan. They were also adopted by Israel and the Palestinians in the Oslo Accords, though the promise of Oslo has yet to be fulfilled. The framework built upon these requirements remains the only basis for achieving a comprehensive peace in the region and between the parties. The Security Council and the General Assembly have reflected this time and again in their respective resolutions. This framework also remains the basis for ongoing U.S. efforts to facilitate a lasting peace. Earlier this month, U.S. Secretary of State Blinken traveled to the region for the 5th time since October 7 and discussed the sets of commitments that all parties would need to make. As he explained, there will be difficult choices necessary to realize the vision of the long elusive prospect of true peace and true security. He also reinforced that the diplomatic path to a just and lasting peace and to true security for all in the region continues to be a path to an Israel that is fully integrated into the region with normal relations with the countries of the region and with firm guarantees for its security. He underscored that this must include a concrete path to a Palestinian state living side by side in peace and security with Israel. The United States is not alone in this effort to achieve and sustain the goal of the established framework that the Security Council and the General Assembly have created and continue to endorse. Countries and organizations around the world, some of which are participating in these proceedings, continue to reiterate the imperative of reviving the peace process and urgently achieving the two-state solution. Our written comments collect a number of statements made to that effect. Mr. President, members of the Court, I turn now to the second part of my statement and the important role the Court can play in preserving and promoting this established framework. The Court has appropriately recognized that its role in rendering an advisory opinion is to assist the requesting UN organ while taking care to avoid a result that could undermine the determinations of the Security Council and its primary responsibility for the maintenance of international peace and security. This feature of the Court's advisory function has several important implications for the Court's work in this proceeding. I will discuss 3 of them. First and fundamentally, the Court should not take up the suggestion of some to interpret the questions in this proceeding as encompassing the entire question of Palestine. The request seeks advice only with respect to the legal consequences of the conduct of one of the parties to the underlying conflict. This one-sidedness, which contrasts with the reciprocity inherent in the established framework, necessarily must inform the court's approach to this advisory proceeding. Second, contrary to the assertions of some participants, in calling for the court to take this measured approach to the question referred, the United States is by no means suggesting there is no role for the court, nor is it the position of the United States that the court must refrain from considering violations of international law or the legal consequences thereof. Participants who have said as much have misunderstood us. Our argument is grounded in respect for the UN Charter and the roles and responsibilities assigned to the UN's principal organs. The court's advisory function was designed to assist the UN's principal political organs in the proper performance of their respective functions. In exercising its advisory role, the court must necessarily consider the extent to which the Security Council and General Assembly have taken action to address a matter of international peace and security, particularly where, as here, they have directly and repeatedly endorsed a specific framework for achieving peace. None of the Security Council's resolutions have suggested altering or departing from this framework. In fact, as recently as late December, the Council, in Resolution 2720, reiterated its, and I quote, unwavering commitment to the vision of a two-state solution where two democratic states, Israel and Palestine, live side by side in peace within secure and recognized borders, consistent with international law and relevant UN resolutions, end quote. And at around the same time, the General Assembly likewise stressed in Resolution 78/192, quote, the urgency of achieving without delay an end to the Israeli occupation that began in 1967 and a just, lasting, and comprehensive peace settlement between the Palestinian and Israeli sides, based on the relevant resolutions of the United Nations, the Madrid Terms of Reference, including the principles of land for peace, the Arab Peace Initiative, and the Quartet Roadmap to a permanent two-state solution to the Israeli-Palestinian conflict. International law has a central and important role to play here. Within the established framework, the Security Council itself, including in recent resolutions 2172 and 2720, has demanded that all parties comply with their obligations under international law, including international humanitarian law. And within the framework, the Council has also sought to remove obstacles to the achievement of a two-state solution, including the establishment of civilian settlements, destruction of infrastructure, demolition of homes, and the failure to prevent acts of terrorism. The Council has likewise emphasized that the parties should be held to their commitments. For example, Security Council Resolution 1850 notes the irreversibility of the bilateral negotiations between the parties and urges, and I quote, an intensification of diplomatic efforts to foster in parallel with progress in the bilateral process, mutual recognition and peaceful coexistence between all states in the region in the context of achieving a comprehensive, just, and lasting peace in the Middle East. In any consideration by the court of these or other issues, the challenge for the court is how to provide its advice in a way that promotes the framework rather than disrupting its balance, potentially making the possibility of negotiations even more difficult. In this regard, it would not, as some participants suggest, be conducive to achievement of the established framework to issue to issue an opinion that calls for a unilateral, immediate, and unconditional withdrawal by Israel that does not account for Israel's legitimate security needs. Whatever the court's opinion on the legal consequences of particular violations of international law, such an outcome would be contrary to the established framework, which the Security Council and General Assembly have structured around the two interdependent and inseparable elements, not only withdrawal, but also the conditions necessary for peace and security for all states in the region. An enduring peace requires progress on both of these balanced elements. In addition, as noted in the U.S. written comments, the establishment of this framework by the Security Council and General Assembly is a salient feature of these proceedings, distinguishing it from other proceedings. Mr. President, members of the court, as Secretary General Guterres remarked just a few weeks ago in connection with ending Israel's occupation, quote, "A lasting end to the Israeli-Palestinian conflict can only come through a two-state solution. Israelis must see their legitimate needs for security materialized, and Palestinians must see their legitimate aspirations for a fully independent, viable, and sovereign state realized, in line with United Nations resolutions, international law, and previous agreements." Under the established framework, any movement towards Israel's withdrawal from the West Bank and Gaza requires consideration of Israel's very real security needs. We were all reminded of those security needs on October 7, and they persist. Regrettably, those needs have been ignored by many of the participants in asserting how the court should consider the questions before it. In sum, it is important that the court keep in mind the balance that the Security Council and General Assembly have determined is necessary to provide the best chance for durable peace. Mr. President, members of the court, I turn now to my third point. In carefully considering how its advice might best support progress within the established framework, the court should not deviate from longstanding principles of international law, including with respect to the law of belligerent occupation. As set out in the written submissions of the United States, international law does not provide for an occupation itself to be rendered unlawful or void, based either on its duration or on any violations of occupation law. Under international humanitarian law, a belligerent occupation is established when the customary international law standard reflected in Article 42 of the Hague IV regulations is satisfied. The fact of an occupation is the basis for the occupying power to exercise its authority over occupied territory. The fact of an occupation is also the basis for the application of the legal rights and duties applicable to an occupying power. For example, the Fourth Geneva Convention prohibits an occupying power from transferring parts of its own civilian population into territory it occupies. Even if an occupying power violates such a prohibition, as has been argued in this proceeding and as the court found in construction of a wall, the legal status of the occupation would not change as a consequence, because the occupation continues in fact. Importantly, this means that the protections of occupation law, including its protections for civilians, would continue to apply. We were surprised to hear that some have questioned in this proceeding the U.S. position on the illegality of acquisition of territory by the use of force. We have repeatedly stated our strong opposition to any unilateral attempts to change the peacefully established status of territories by force or coercion anywhere in the world, and have reaffirmed that the acquisition of territory by force is prohibited. And as our written statement made clear, in reference to this and other situations, the Security Council and the General Assembly have declared that any actions to change the status of occupied territory are null and void and do not affect the continued application of the Fourth Geneva Convention. With respect to duration, international law does not impose specific time limits on an occupation. That said, belligerent occupation is a temporary measure for administering territory under the control of belligerent armed forces. A few days ago at the Munich Security Conference, Secretary Blinken emphasized that it is more urgent than ever to proceed to a Palestinian state, one that also ensures the security of Israel and makes the necessary commitments to do so. In light of these considerations, the court should not find that Israel is legally obligated to immediately and unconditionally withdraw from occupied territory. The court can address the questions before it within the established framework based on the Land for Peace principle and within the parameters of established principles of occupation law. Mr. President, members of the court, as I said at the outset, you have a difficult task before you. Others have asked you to broadly construe the questions and the law. They have asked you to try to resolve the whole of the dispute between the parties through an advisory opinion addressed to questions focusing on the acts of only one party. The United States disagrees with that this approach would be consistent with the court's role within the United Nations or the established UN framework for achieving peace through negotiations. Hamas's attacks, hostage-taking, and other atrocities, the ongoing hostilities and the suffering of Palestinians in Gaza, and the violence in the West Bank reinforce the United States' resolve to urgently achieve a final peace that includes the full realization of Palestinian self-determination. The current crisis illustrates the vital need to achieve this peace, this final peace, with a Palestinian state living safely and securely alongside a secure Israel, fully integrated into the region. As Secretary Blinken said, quote, "We're not going to have durable security for Israel unless and until Palestinian political aspirations are met," end quote. The lack of meaningful progress on a negotiated end to the conflict and establishment of peace between the parties and for the region cannot and must not persist. The Security Council and General Assembly continue to make clear their support for the two-state solution and the established framework to fulfill it. This conflict cannot be resolved through violence or unilateral actions. Negotiations are the path to lasting peace. For these reasons, we respectfully encourage the court to carefully calibrate its advice in this proceeding to support and promote final realization of peace and stability within the established UN framework set out in Security Council Resolutions 242 and 338. Mr. President, members of the court, this concludes the oral statement of the United States. I thank you for your kind attention.
I thank the delegation of the United States of America for its presentation, which brings to a close this morning's hearing. The court will meet again this afternoon at 3 p.m. to hear the Russian Federation, France, the Gambia, Guyana, and Hungary. The sitting is adjourned.